Hi there, I'm Savannah Mextro with Mannor Law Group, welcoming you to another Webinar Wednesday with esteemed estate planning and elder law attorney, Bob Mannor. Only around half of all Americans actually have a will. But what happens to those of us who die without one? More importantly, what happens to those you leave behind? Get answers to these tough questions on this week's Webinar Wednesday. But before I pass the mic to Bob, I'd like to cover a few housekeeping details. First, note that even though Bob is an attorney, today's webinar will not give specific legal advice. If you have a question about your unique situation, please contact us after the webinar. Also, if you have a general question during today's presentation, we encourage you to use the chat box. We will save time to review questions during the webinar. If for some reason we don't get to your question, we will contact you after the presentation. Also note that today's presentation will be recorded and the replay will be sent tomorrow so that you can share this with family, your friends, or anyone who you think could benefit from hearing this information. Now, why should you listen to what the folks at Mannor Law Group have to say? We are a nationally recognized and respected elder law and estate planning firm. All three of our attorneys are accredited by the Veterans Administration to assist veterans with claims and appeals. Our managing attorney, Bob Mannor, is nationally board certified as an elder law attorney by the National Elder Law Foundation. He is one of only 19 attorneys in Michigan to achieve this designation. Bob is also a leader among elder law attorneys in Michigan. He is currently chair-elect of the State Bar of Michigan Elder Law and Disability Rights Section and past president of the National Academy of Elder Law Attorneys, Michigan chapter. And my personal favorite reason, Mannor Law Group has been honored by readers of our local paper as the best or favorite law firm for the last 8 years in a row. Now, without further ado, I'd like to welcome attorney Bob Mannor.
Hi, folks. We're going to get right into this. This is always a great topic. And so there's a lot of confusion that goes around this topic of what happens if you die without a will. You know, occasionally I'll hear people say, oh, well, if you die without a will, everything is going to go to the state. Well, that's not true. Or it'll be fine if you die without a will, everything will just go, you know, to my spouse or to my kids. And that might not be true either. So let's talk about this. So we're going to talk about it first. There's a word that they use for this when you die without a will. They call it intestate. Now, you don't have to remember that word, but that's the legal term. And then they have this phrase called intestate succession, meaning who are your heirs under intestate succession. So we're going to talk about this from a standpoint of, in theory, what's supposed to happen or what the law says happens if you die intestate, meaning without a will. And then we're going to talk about in reality, because not everything's going to follow that same path. So a lot of people assume, okay, well, if the law says this is who gets your stuff when you die, that's going to be the defining answer. And you're going to see in a minute that there's going to be a difference between what happens in theory and what happens in reality. And often it's going to be a mix of the two, in that some things are going to go according to intestate and some things aren't going to go according to intestate, and you'll see that in a second. So let's talk about intestate first. Okay, so what does the state of Michigan say happens to your stuff in the event that you die without a will? So the first thing that we're going to look at, well, what if you die and you have children but no spouse? Well, that one is actually one of the simpler ones. So if you have children but no spouse, or your spouse predeceased you, then your children will inherit everything. They'll each have an equal share. And when I say children, then what that means is it's going to go down each family. So if you had 4 kids and one of them passed away, but the one that died had 2 kids, then it's still going to be 4 shares, but one of the shares, the share of the deceased child, will now go on to the grandchildren, those 2 grandchildren from the deceased child. So each family will still get a 1/4 share under that scenario. So that seems pretty straightforward. That seems pretty simple, but now let's throw some wrinkles in here. So what if you have a spouse but no descendants, no kids, but you have a spouse? Well, everything goes to your spouse. That seems pretty simple too, right? And that's normally what a lot of folks would want. Nothing out of the ordinary there. Now let's take a look at some of these wrinkles that come in. So what if you have a spouse and you have kids from you and that spouse? So all of your kids are together. You would think, a lot of times you would think everything would go to the spouse. Well, you're going to see a difference of what we say in theory versus in reality, but in theory, the spouse gets the first 150,000 and then half of the other assets. And your kids then get the other half after we subtract the first 150,000 and then have half go to the spouse. So that was what would happen if it goes intestate and the assets are in your name when you die. Okay, so we're going to talk about what that means in a second. What if you have as a second marriage? What if you have kids from your first marriage and at least one child from your second marriage, and then you die while you're married to your second spouse? Well, interestingly enough, it's exactly the same as if you had all of your children together. So it doesn't matter if you're on your second or third or fourth spouse. In that case, as long as you had a child together, then your spouse inherits the first 150,000 and then half of the other assets, and everything else would then go to your kids. All of the kids, any of your natural or adopted children. All right, so let's take another wrinkle here. So now we're getting into some more interesting scenarios. What if it's a spouse and you have no kids together? So you have kids, but not with your spouse. So it's you had kids from a previous relationship or a previous marriage. You get married. What's going to be the default of what happens to your stuff when you die? And the answer is, if you don't have a will, it's going to go according to intestate, and your spouse would inherit now the first 100,000, not 150 like before, and still half of everything else. And then your kids would get the other half. What if you have a spouse and parents? So no kids, you're married, you have a spouse, but no kids. So no kids from a previous relationship, no kids from this relationship. Well, your spouse gets the first 150,000 and 3/4 of everything else, but your parents actually get the last quarter. So not everything would go to your spouse in that situation. What if you have parents but no spouse or no kids? Well, then everything goes to the parents. And then what if you have no spouse, no kids, and no parents? Then it would go to your siblings. And if your siblings aren't alive, then it would go to your nieces and nephews. And your nieces and nephews aren't alive, it would go on, and so on. And there's a whole list of intestate succession, but you get the idea behind that, okay? So generally, that is the idea here. And that's the theory of what intestate succession is. Now let's talk about real life. So what do I mean by in real life? Well, intestate succession doesn't cover everything. And the reason it doesn't cover everything is because there's things that are considered part of the probate estate and things that are not. So what are things that don't follow that pattern that we just discussed? What are certain assets that don't follow that pattern? And what's interesting about this, what was particularly interesting about this, is it's not just those assets that if you don't have a will, but even if you have a will, these assets will not follow that will, and it will not follow that pattern that we just mentioned for intestate. So those are assets where you have property that you own with somebody else. And you see here, I wrote maybe. What do I mean by maybe? Oops, sorry, go back here. So why do I say maybe if you have assets with somebody else that they don't follow that pattern? And the answer is it depends on the nature of your ownership, particularly as it relates to real estate. So this gets really messy when it comes to real estate because one or two words different on that real estate deed, and it's going to make all the difference in the world. And so people think that they can draft their own deeds, or they get this form from the internet, or form from the county, or wherever they get the form from, and it causes all kinds of problems because just because you own property with somebody else doesn't mean that you're going to inherit it. So there's a difference between what's called joint tenancy, tenancy of the entirety, and tenancy in common. And so real estate, the default is tenancy in common. So if you and your brother own something as tenancy in common, that means you each own half. So will your brother inherit it if you die? No, your share would go through the intestate succession and go through probate. Okay, so because you own it half instead of owning it with your brother. Now I've even seen this where husband and wife own things tenancy in common, and that is not typically what they expect, but I've seen this actually very recently where normally a husband and wife own things by what's called tenancy in the entirety. And the idea here is that in the recent deed that I saw, the lawyer, for whatever reason, got rid of the tenancy in the entirety and made them own it by what's called tenancy in common, meaning they each owned half. Problem with that is one spouse dies, what happens to the half of that was owned by that spouse? You'd think it goes to the spouse? No, it goes through probate. It's going to go through that intestate succession or in through your will. So on any of these scenarios, these assets will not follow the pattern of intestacy, and it will not follow what you have set out in your will if you have joint property under any of these conditions. So let's see if we can clear that here. So the next thing to talk about is anything that has a beneficiary. Okay, so if it has a beneficiary, then it will not follow the pattern that we've just talked about. It will not follow the intestacy. It also will not follow your will. So a lot of people think, oh, I've got my will. It says divide everything equally or leave everything to my spouse, but that's not true if we have a beneficiary on the account and the account's only in your name. That's also not true if we have transfer on death or payable on death on the account. And finally, and most commonly, it doesn't count if you have assets transferred to a living trust. So this is really important because a lot of people are going to use the living trust as a means to make plans for all of this and not have it follow through to go through probate. Okay, so you notice what I keep saying, and I want to make sure I'm very clear on this, whether you go through intestacy or whether it goes through the will, in both cases it goes through probate. So what's one of the ways to avoid probate? We use a living trust. Okay, so that's a very common way to make sure that we have a plan that's going to cover every contingency, going to make sure that if we want it to go to our spouse, it goes to our spouse. If we want it to go to our kids, it goes to our kids, and so on. Okay, so now let's take a look. What's usually the best way to avoid probate? So if you don't have a will at all, it's called intestacy. If you have a will, you set out your terms, but it's only going to follow those things that don't have a joint owner or don't have a beneficiary or transfer on death or are not in the trust. So one of the common ways that we look at to avoid probate is going to be through a revocable living trust. So what is a revocable living trust? Well, you see in my picture here, I call it the little red wagon. I'll explain why I call it the little red wagon in just a second. But the most important thing here is that the trust is a contract where you're empowering the people that you want to empower. So if you don't want the courts involved, you don't want lawyers involved, you don't want the government system involved, then you can empower your spouse, you can empower your kids, you can empower your best friend or your brother or your sister or your daughter, and give them the authority to handle things in your illness or after your death without having to go through the court system. So the idea then is we've got what we have here. This is one of the things that we do at Mannor Law Group, is that we often look at it in one of these three columns. The first column is where you either are going to go through intestacy, meaning you don't have anything, you don't have a will or anything else, or you have a will. So I like to call the will a funnel. Why is the will a funnel? Because it's a catch-all. You die and you own a house, you die and you have money, it'll catch it, but it'll have to be funneled through probate. Okay, so even if you have a will, you're still going to go through probate in that scenario. Okay, so this is the column for our clients that are okay with going through probate. This is the column for those that want to avoid probate, and we're looking at a revocable living trust. We have all kinds of things that can make it better for the kids and maybe save on taxes and other things like that. We have other presentations that can go through those details, but today's to talk about, what happens if you die without a will. So then there's a third column that we do for those folks that are worried about asset protection, particularly making sure that they don't lose everything to a nursing home or qualifying for veterans benefits. Okay, so those are some ways that people in our office would use that we help you empower your family so that we can stay out of court, protect your assets, things like that. And it's not just having a will, because as we said before, while the will is good, there's a lot of things that don't go through the terms of the will. And number two, the will is going to go through probate. But if you don't have anything at all, it may go in a fairly odd fashion. So let's talk about some of those things where why either having a will or not having a will is not ideal. The first one is if you're in a second marriage. So in a second marriage, a lot of times what you want to do is you say, well, I want to protect my spouse, right? So I want to leave at least the house, or I want to leave some money to my spouse. Well, what happens to your kids then? So let's say you leave everything to your spouse, or you leave some of your assets to your spouse in a second marriage, and then your spouse dies 6 months later. What happens to all your stuff? Well, it's going to go to your spouse's kids. It's not going to go to your kids at all. Your kids are going to be cut out completely because you set it up, whether it went through intestate or whether it went through intestate, your kids would get something out of it, if assuming it was more than the $150,000 that your spouse would automatically get. But whatever your spouse got is going to go to their kids. So that's why it's important with a trust, for example, that we would be able to make a plan that says, okay, well, I want my spouse to have access to this money. I want them to be, be protected and have a place to live and all those types of things. But when they're gone, I want my kids to get it. When my spouse is gone, I want my kids to get that. You can do that through a trust. You really can't do that through a will. Okay, you can't do that without a will, with an intestate. So that's one of the examples. The second thing is if you wanted your spouse to get everything, not having a will is going to create a problem, because as you saw through the intestate, there might be some issues where your spouse isn't entitled to everything and your kids would get a portion of it. So that's where both a will and a trust could solve that problem. But even if you've been married to the same person all your life and you have all your kids together, the intestate issue is not going to result in the results that you thought you were going to get, because only a portion of it actually goes to the spouse. And there's no protections in case the spouse remarries, or what the spouse does after you pass away. Plus, some of it, they might not be entitled to everything. The kids might get part of that, and that might be things that the spouse needs actually to live on. So so that's what happens if you die without a will. That's what happens if you die with a will, and here's some of the best alternatives to avoid probate and go through that. So that was a lot of information. You may have some questions about that. So Savannah's going to come on here and she's going to explain how do you get your questions answered, or if you would like an appointment with us, how to get an appointment with us.
Thanks, Bob, and thanks everyone for joining us today. As Bob mentioned, we do have some easy ways for you to get in touch with our team, whether you'd like an appointment or you just have a few questions, we're here. So of course, you can always give us a call. Our phone number is 1-800-990-6030. Again, 1-800-990-6030. You can give us a call. Our team will answer, ask you a few questions. You can ask us a few questions, and then we can decide from there, what you'd like to do. If now's not a good time to call, but you want to connect with us, you can also click on the link that I just put in the chat. I'll email this link to you in a few minutes too. But that link, when you click it, it will take you to a calendar, and you'll choose a day and time when a member of our team can call you. And again, this call is for you. There's no risk, there's no obligation, there's no cost. You can just go ahead and ask questions about our firm, ask general questions, and then we'll just get some information about you and your situation as well. So we look forward to hearing from you. We're happy to help. And of course, we're happy you could join us today. Thanks again, and we look forward to seeing you next week.